Caribbean, joined by water, connected by culture, and linked by a common heritage.
We are looking at 50 years of the Eastern Caribbean Supreme Court, justice in the region. I'm Beverly Sinclair, who is your host for this program. We have Ruggles Ferguson, former president of the OECS Bar, former president of the Grenada Bar, very prominent attorney in his own right. We have Renee Batiste on our virtual link. You know, she is the president of the St. Vincent Bar. We have eminent QC and Henry over there in Antigua. And we have been having a really interesting discussion on the unique features of the court and how the court has evolved over 50 years of serving the Eastern Caribbean. The theme for this observance is celebrating the past and embracing the future. And I want to look now at embracing the future. What kind of future are we looking at for the court? Just to use an example, we are sitting here in the studio of Flow One in Grenada. We have Renee with us virtually from St. Vincent. We have Anne with us virtually from Antigua. We are broadcasting on the CaribVision platform right across the region. We are streaming on Facebook. Everything is happening digitally, moving at the speed of a click. And as we discussed earlier, justice is still a very slow carriage, trudging along. So when you talk about embracing the future, and what are we looking at? What kind of future?
Well, in point of fact, we are at a future of a court which is even more driven by technology. I mean, we are trudging along in one sense, but in another sense, the court, in fact, is trying to push forward and to use technology to provide greater access to justice, whether it is by having lawyers and judges not being in the same space, and that happens on a routine basis in our court even now, to electronic filing of documents. That is something which is contemplated under our rules. It may not happen as extensively as we would think appropriate, but clearly that is the wave of the future. And in point of fact, I attended a lecture a couple of weeks ago where the speaker, who is a retired Chief Justice of Appeal of the Eastern Caribbean Supreme Court, Justice Don Mitchell, foreshadowed that there may come a time when we don't even have courthouses and court buildings, because the judges will be seated wherever it is that they are located, and the lawyers and the litigants wherever they may be. I mean, we did a case the other day in court in Antigua where our client is a person who is located in the United States, had different challenges which made it impossible for her to travel to Antigua for the case. She sat in her home in the United States, and we did the case virtually. So that is something which is not commonplace, but is certainly contemplated by our rules. And I think that is where we're heading. Now, in terms of efficiency, we are still going to have to ensure that when documents are filed, that they are properly recorded, that files don't get overlooked, which is something which happens in the real world. Papers get lost, misplaced. Those kinds of challenges will continue to affect the efficiency of the court, but that is the way of the future, the automation of litigation and court processes. It has already started, it has to take root. But I think if we can go back a little bit in terms of the discussion that we were having about the question of funding, because I think Renee had mentioned that we need to get the issue of the trust fund and those kinds of issues and how we fund the court before on the agenda of the heads of government. I think that a lot of these things need to get onto the agenda of the people of the region. There's a great difference, or there's a great divide between what I know as an attorney at law who has been practicing for many years about the court system, its shortcomings, and the good things about it that members of the public don't know, because they only see the cost of pursuing litigation, the pace being slow. We live in a world where we need instant gratification. And so that I think that there's a sense in which, in order for us to be able to move forward as a court and to embrace that technology that is going to move us forward and keep the trajectory in the right direction, we are going to have to engage more and more with the people of the region.
Renee, break it down in small bites. We talk about evolution over the past 50 years, but evolution takes time. Embracing the future, we all know that a whole lot has changed over 50 years. When you look at the future, what can we expect from the ECSC within the next 5 years? We talk about most things happening in 10-year cycles.
I think within the next 5 years, because we are focusing now on the celebration and marking the 50th anniversary, one of the programs that has been about to be implemented, because we had a bench bar meeting, and the judges indicated their willingness to assist with the public education trust for the general public to understand the court and the court system and what happens. Because when people understand, and they also hear it from not just the lawyers who are involved, who are part of the process, but they also hear the judges speaking about it, they will help to increase the confidence of the people in understanding the system.
Renee, I have to ask you to hold that thought anyway. We have a caller on the line from St. Vincent. Go ahead, please, caller.
Hello, good night.
Yes, good night. Please go ahead.
Yeah, I'm questioning the role of a DPP. Normally when you have cases, you have the judge, you have the people giving evidence in the case, but when you have the DPP putting out a case, he alone acts as against judges and lawyers and people who give evidence and so forth. So I'm wondering how professional he can be.
Thank you for your question. And we have 3 eminent lawyers on our panel this evening. So one will explain the role of the DPP. You want to go ahead, Ruggles?
I didn't hear him.
Because that's what the caller was asking. What's the role of the DPP?
Yes, the Director of Public Prosecutions is an independent post under most of our constitutions, certainly throughout the OECS. And the DPP ultimately is responsible. He can institute criminal proceedings. He can take over. And when I say he, I mean he or she. If the DPP is female, he or she can continue legal proceedings, criminal proceedings. He or she can nullipros or end certain legal proceedings. So it's an independent post. The DPP ultimately is the head of prosecution, and it is the prosecution. Remember, we are in an adversarial system. So in every criminal matter, there will be the prosecution and there will be defense. The prosecution is responsible for instituting criminal charges. So somebody is arrested and charged. The defense will look after the interests of the accused. So ultimately, a DPP is powerful under the Constitution. He or she can take over legal proceedings and certain criminal proceedings as he or she sees fit. So is that independent? Is a constitutional post.
So, caller, that is why it always seems like the DPP is coming up against the rest of the court. A lot of these defense teams are very big. Sometimes you have several lawyers in a defense team. You will have the DPP probably facing the court, one person at a time.
Well,
in some cases.
Well, it's because the DPP has a department, an office. So you have the prosecutors.
Right. But sometimes it would be just one person from that department, and you have a team of defense lawyers. So to someone looking on, it seems very unbalanced. I'm not saying it's always the case.
Yes.
You know, because as you said, it's a department, so it's a matter of how the department functions.
The office of the DPP.
But I'm just referring to what someone will see when they step inside a courtroom. You see the defense, you see the prosecution, and you'll hear the term in the court, and you say, well, why does it look so off balance?
Well, but I think the caller, and I'm subject to correction here, was raising the issue in the context of the power of the DPP. The DPP seems to be a powerful force. That indeed it is, because we can end criminal proceedings, you can nulli-pros as the technical term, and discontinue, because you have that authority in our constitution in section 71. Continue,
as we just
discontinue.
saw in the Oscar Bartholomew case, where the DPP did have the power under the constitution to do what he did.
Well, to appeal. In that case, he would have appealed.
To lay the charges.
Yes.
He was empowered to do that. So,
right.
So yes, I do take that point. The caller could probably have been referring to that aspect of it as well, to the powers of the DPP. But the DPP is empowered under the Constitution. He is not just a regular lawyer.
Right. It's not just, it's a constitutional post.
That's
constitutionally protected, in fact, post.
Exactly. And you know, earlier we have touched on a number of issues, and unfortunately we have not delved into all of them. But there is one matter we touched on which I did promise to get back to, and that was the issue of the magistracy. Because the magistracy is the foundation of the legal system. It's where most people enter the legal system. You first get in trouble with the law in most cases. That's the first place you go, the magistracy. But it's one of the problem areas in the court system. Justice Saunders, when he was here when he was in Grenada for the Sir Archibald Ned lecture, he mentioned it. He called for sweeping reforms to upgrade and give some kind of status to the roles of the magistracy, which he says one of the major issues is the link to politics, because the magistrates are perceived as just a political branch, then, so to speak. And when you look at how magistrates are appointed, the fact that checking across the region, you find that most magistrates are under contract, hired by the executive. Then, how are we going to fix this system? What do you see as the solution for the magistracy when really and truly it's not being treated the way that it should be, to give some kind of confidence? Renee is the one who used the term a while ago, to give the layman some kind of confidence in the system, that the system works.
Right. Important. Yes. Sorry, well, let me...
Renee, you wanted to respond to that?
Yes. There have always been persons who have mooted from time to time the question about the appointment of magistrates and if there is any political influence in the appointment of magistrates. And so far, you will always have people who are critical of the process, but the majority of the work, as Robbers will tell you, the majority of especially in the criminal court, the majority of it in the criminal division is dealt with at the magistrate level. They dispense quite a lot of the criminal cases, and especially with us in St. Vincent, where we have the Grenadine Islands, where you have to go down to the courts in the Grenadine Islands to ensure that persons there also serviced by a magistrate. And the establishment within the magistracy, where there's a serious offences court, and coming out from the police in supporting that you have all the different new criminal units, because as one prime minister said, that the criminals are also becoming quite sophisticated. And so you have to also improve the training in the magistrate court and the
Renee, the issue is not the volume of work that we know the magistrates do. What we're talking about is how they are protected in the system, their status in the system, how they are hired, how they are fired. But we have to take take a break. So when we come back, we have to take a break. So when we come back, we will get an answer to those questions. Welcome back, viewers. We are in the final moments of this edition of Time to Face the Facts, and we're looking at 50 years of the ECSC. When we went on the break, we had touched on the magistracy, and we want to look at possible solutions for raising the status and actually elevating the profile of magistrates in the judicial system. Renee, you were giving your input on that issue, and we have a very short time to wrap up, so we have to make our points very quickly at this stage.
I think that long ago, persons looked on being in the magistracy as a preferred course for their career. And I think in late 80s, early 90s, that's when we started to have difficulty in filling the post. And so they had to take what they can get out there, which was people who would go on contracts, take them on a contractual period for 2 years or 3 years, renew another 3 years. And but because now it is evolving, I believe it is evolving where you're going to have much more specialization. I think that some persons are now looking at it, because from where I sit as president of the bar, from time to time I get attorneys asking me about joining the magistracy, wanting to become magistrates, because they're interested in, they're seeing the training that is being made available through different projects that have been sourced by the Eastern Caribbean Supreme Court, where they do training for magistrates about three times a year, because you will hear that magistrate has gone on training towards the end of July, towards the end of February or something like that, where you see an increased amount of training, so that the capacity building has now been put into the post. And I believe that is also raising the profile. And because the magistrates are dealing with so much more work now, they always had a pretty heavy schedule, but there's more now on their plates. And as they say, the crime has become more sophisticated. You see, there is an increase. I'm getting calls of people asking me about, how can I become a magistrate? How can I join the magistrate service? And what do I need to have? How many years should I have of practice before the bar? And things of that nature, because they are also looking. I said, why? Well, you get in training, you get in the opportunity to be more sophisticated in the way that for writing of judgments and so on. They're seeing that. And I think that in the next couple of years, we will see more people wanting to go, because they have asked questions, especially with so many young people that have doing law, reading law, and wanting to join instead to get to the bench.
And what do you see as a solution? And we have you have about a minute.
I was trying to review the legislation, because in Antigua the law was passed to make the appointment of magistrates a matter of the Judicial and Legal Services Commission, which it had not been in the past. Because in the past, magistrates were appointed by the executive branch, were put on contracts, and of course that would have it would immediately suggest that there's a compromise of the independence of the judiciary insofar as the magistracy is concerned. The law was changed in Antigua within the last 2 or so years, so that the magistrates in Antigua are not appointed by the executive any longer. That may not be a matter of public knowledge or widespread public knowledge, which means that there's a sense in which the comfort that members of the public could get from knowing that you have independent members of the judiciary at the magistracy level or the magistrates court level has been lost if they do not know that that change has taken place.
Okay.
That change has taken place in Antigua. I really thought it had happened across the region. That may not be the case. I don't know.
Yes, just briefly to indicate in terms of magistrates and reason the status of magistrates, the whole idea is to integrate, and that's a project of the Eastern Caribbean Supreme Court. We have been hearing about it for several years now too. That's the integration of the magistracy in what is regarded as the higher judiciary. So, for example, for the appointment of judges, now certainly in Grenada and several of the other islands, ultimately the Judicial and Legal Services Commission would recommend the appointment, will actually recommend to the Governor General the appointment of the magistrate. But for judges, the application is made directly to the JLSC. For magistrates, the initial recommendation comes from the AG's chambers. So there is the executive input. So the whole idea is to make it standard. So the appointments of magistrates as judicial officers, because they are also judicial officers, they should be completely independent of the executive and face the same process as judges as judges face.
Independent as the system allows.
Independent in terms of that body, the Judicial and Legal Services Commission, on which there are no government appointees, like they do for judges. The same should happen for magistrates.
I have to stick something in Ruggers in just about 1 minute.
Yes.
What is the role of the justices of the peace in this system?
Well, the JPs mainly they can do. You can go before them affidavits. For example, they play a major role in the criminal justice system. So, for example, when somebody is arrested and charged, and you are placed on bail, then you go to the JP in the community because the bond has to be signed. And you would go before the JP. They don't have to wake up the magistrate in the night. So the JPs can do things like affidavits and so. And in fact, in our law, though it doesn't happen, the JPs can actually sit. It does not happen in practice, but based on the old law, JPs can actually sit on the bench at the magisterial level.
Okay.
Yes, but they mainly do things like affidavits, like for example in Caracol, when you have to send affidavits down here signed before an oath officer, it's usually before the JP, and in all communities.
Do they have any role in the electoral system in the Parliamentary Elections Office?
JPs, no, to the best of my knowledge.
They don't.
No,
okay.
To the best of my knowledge.
Renee, Anne, thank you very much for joining us this evening. And I could give you each about 30 seconds, if you will not take more than 30 seconds, just to give me your final word on the ECSC in its 50th year. 30 seconds, Renee, and 30 seconds for Anne.
Looking forward to the future of our Eastern Caribbean Supreme Court. Hopefully that we can get our various courtrooms and headquarters so that we can more efficiently administer justice, improvement in the digital literacy throughout the court administration system, and the independent funding for the Eastern Caribbean Supreme Court, and an increase in public education and awareness to help the general public understand the court.
Thank you, Renee. Let me get Anne's 30 seconds.
Well, my 30 seconds is going to be to adopt everything that Renee just said and to add that programs like this will be part of the initiative to be able to get members of the public involved in what happens in the court, to be able to improve the system even more than we have seen over the last 50 years.
And Ruggles, I think we have had your last word already, Ruggles.
Well, but certainly utilization of technology, more public legal education. I can't overemphasize that. Continuing legal education for judges and continuing judicial education for magistrates and judges.
Thank you, viewers. Thank you very much for joining us for this discussion, and we look forward to being with you again on another edition of Time to Face the Facts.